Hello, everyone. Good afternoon. My name is Ellie Krug. I'm the Executive Director of Call for Justice, and we're here today to do some further training of United Way 211 on various legal topics and legal referrals. Today's topic will be criminal law, and for the next approximate hour and 15 minutes or so, we'll talk about criminal law, what it means, what's involved, and I will try and keep it interesting and a little bit, at least a little bit lighthearted. So let me begin by telling you a story that relates to criminal law and my role before as a trial lawyer. This is where the table flips. Probably about 10 years ago, give or take, I was defending a truck driver, and I used to do a lot of transportation law as a civil lawyer, where I would represent trucking companies, truck drivers, railroads, those types of things. You know, the entities that when people tangle with them, they don't usually get whiplash; they get killed. So I had a truck driver who had been given a ticket for having parked his truck too close to an intersection when he was on the shoulder. It was on a rural roadway, not on an interstate, and there was a 4-lane kind of highway there, and a woman had somehow lost control of her car as she was coming to the intersection. I think the weather was bad, and she ended up running into the truck and being killed. And the truck driver ended up getting a ticket for parking too close to the intersection, too close to the roadway. And because there were implications in that case, civil implications. So now we're getting into, I'm telling you this story to help give you the difference between civil and criminal. Because the truck driver and his trucking company were subject to getting sued by the woman's estate, they hired me to defend the truck driver on this ticket. And so we're out in rural Iowa at a rural courthouse, and I have this truck driver sitting with me at the table, and we have what then was a country magistrate. So it's somebody who's part-time lawyer, part-time magistrate. We have a court reporter there, and then we have the county attorney's office representing. And so now you know the way the criminal works is you've got the prosecutor is the person bringing the charge is the county or the city or the state where the accident or the criminal event happens, and you have a judge just like you would have in a civil case. Well, in this case, what had happened was that before my fellow got charged with the ticket, he happened to talk to the police officer, I think a state trooper or a deputy, over the telephone. And my truck driver had made a couple of statements over the telephone that probably weren't statements that were favorable to him. And so while we were at the courthouse, and by the way, the police officer had tape recorded the interview with the consent of the truck driver. This was obviously before the truck driver talked to me. And so while we were at the trial, a couple of things happened to help highlight what this difference is between criminal and civil. At some point, the prosecutor wanted to call a witness who had been with the trucking company because he had also, this police officer had also talked to the truck driver's boss. I know it's a long story, but work with me here because it'll be worth it at the end. And so the prosecutor asked to call the truck driver's boss. Now, what the prosecutor had not done is he hadn't subpoenaed the boss to this trial. He had just gotten over the telephone, he had gotten the boss's agreement that he would show up to the trial, but he didn't subpoena him. And what the prosecutor didn't know is that an hour before I had sat and had breakfast with the boss and the truck driver. And my very first question to the boss was, were you subpoenaed to come to the hearing? And the boss said, no. And I said, well, guess what? You're going to sit here and have coffee while we go to the courthouse. And so as we were at the courthouse, when the prosecutor said, I'd like to call X, the boss, I said the boss isn't here in the courthouse, which was absolutely true. And then the judge said to the prosecutor, did you subpoena the boss? And the prosecutor said, no, I didn't subpoena the boss because the boss had told me that he would be here. And the very first thing the judge said at that point was, since when do you take anybody's word for it? So at that point, the prosecutor didn't have the boss as his witness to prove his case. Now remember, from our written materials, that the prosecution, to prove a case, has to do it beyond a reasonable doubt. And I will get to that in a second. But in order to prove a case, you have to have evidence. And how do you have evidence in a case? You have to have it through witnesses or through documents. But usually you have to have a witness that's going to verify a document. All right? So that left just my fellow here, okay, who's being charged with a crime. Now, you know from the written material that one of the things about criminal law that's different from civil law is that if you're charged with a crime, the United States Constitution says you shall not be compelled, you may not be compelled to testify against yourself or to incriminate yourself. So that means that the prosecution cannot call the accused to the stand. Can't do it. Because obviously if the prosecution put the accused on the stand, you know, then they would be in a position to cause the accused to testify against him or herself. So the prosecutor knew that he couldn't call my fellow to prove his case, but what he wanted to do was he wanted to put the police officer who had interviewed my fellow by telephone and tape recorded it, he wanted to put the police officer on the stand. And he was entitled to do that. However, when the prosecutor started to get into conversations that the police officer had with my fellow over the telephone, Mary Hatcher gets a gold star because that's exactly right. She said hearsay, and that is absolutely hearsay, okay? Because you can't do it. If you can't have somebody, especially over the telephone, because he had never met my driver, he didn't know who he was. So me being a fairly good lawyer, mediocre to some, but very good for others, I got up and I objected, hearsay. The judge sustained it. So then the prosecutor did something else, and this is why I'm telling you this little story, okay? He tried to get the police officer to play the tape on, you know, the tape of the telephone call, had to have him play the tape. I again objected, and I said, hearsay. And the judge asked the prosecutor, what does this do? How can you get this tape in if you can't have the police officer testify by it? He said, well, Your Honor, it's the voice of the truck driver on the tape, so we don't even need to have the police officer testify to what the truck driver said because you hear the voice of the truck driver saying it himself, okay? Not a bad argument, except for one fact. The prosecutor had never heard my fellow speak in the courtroom. I had told him when we went to the courtroom, my truck driver, I said, you do not talk to anyone. And he did not talk to the police officer when he walked into the courtroom. So the police officer wouldn't know who this fellow was, but for the fact that he was charged and he had to show up, all right? And so what the prosecutor said at that point was, Your Honor, I would ask that the court ask the defendant to state his name, to just make a statement in the courtroom so that the police officers on the stand could hear the voice in the courtroom and could say, Your Honor, that is the voice that I heard over the telephone, and here's the voice that I want to play on this tape recording. Okay? Everybody with me so far? What do you think happened? Who here believes that the judge said, defendant truck driver, okay, say your name or tell us where you live? Who here believes that the court said okay to do that?
Well, it would be self-incrimination.
Yeah.
Oh my God, you guys are so smart. You very are, because that is absolutely right. It would be self-incrimination. Even just to have the defendant say something. Even he wouldn't be under oath. He'd just, he could say today the sky is blue, But no, it would be self-incrimination. And then ultimately, after that was done, and after I looked at a prosecutor who was very frustrated, thank you, and flabbergasted, I said, Your Honor, I move to dismiss the charges by the state. And the judge looked at the prosecutor, and the prosecutor is like, this isn't fair. And I'm like, well, you got to do your job. You have to do it a little bit better than what you've done. Now, the judge then dismissed the charges. So I won. The judge also, at the time he dismissed the charges, he said, I know your fellow is guilty, but the state can't prove it. And so I'm frustrated. Even the judge said, I'm frustrated by this, but this is the way it has to work. Okay, so apart from that being a very long war story and a reflection of some skills at a trial, what does that show us? What does that tell us about criminal cases compared to civil case? The most important thing underlying this concept about criminal law is the idea that it really relates to something fundamental. Actually, two things that are fundamental. The very first thing is that it relates to liberty. Somebody's ability to roam, to walk around unhindered by the government. Because in the civil context, no one, for the most part, ever goes to jail. If they're sued for, usually you're sued for money damages, or you're sued for an injunction to stop you from doing something, but you're never sued to be put into jail. So that's one of the huge differences. But the second thing is that underlying that principle about liberty is the United States Constitution. That everything, the document we all learned about in elementary school, and then back again in high school, and then got tested on in order to graduate and all that jazz. This Constitution thing is really pretty big, because it does underscore that the government is based on the idea that you cannot act arbitrarily. You cannot act in a way that is unfair and without what's called due process. And one of the requirements of due process is that if you're charged with a crime, the government has to follow certain rules. For example, you can't get arrested and they can't put you in a room and beat the heck out of you with a black hose. Okay, well, sometimes they do that, but it doesn't happen very often anymore, and that's because we have constitutional protections. The government cannot come into your house and search it without a warrant. And what is a warrant? A warrant is a document that a judge signs only after being advised of the facts of whatever the alleged crime is, so that the judge has a reasonable suspicion that making this search is legitimate. So this constitutional thing is really, really, really important. And it is the thing that distinguishes from civil cases, because in the civil context, we don't have a constitutional right per se that says you have the right to sue somebody for smashing into your car at that four-way stop on a snowy day in April, And so in the civil context, that means that there are different rules that apply. So let's go back to my truck driver example and give you how that would play out differently in a civil case. So let's assume my driver and I were in the courtroom, but instead of the state, the county prosecutor prosecuting it, it was a private lawyer on behalf of this woman's estate. And my truck driver was being sued for $10 million, which has happened before in other cases. In that instance, what the plaintiff's lawyer could do is he could say, Your Honor, I call to the stand Joe truck driver. And at that instance, Joe truck driver would be required to get up out of his chair, walk across the courtroom, and get in the witness stand. And Joe truck driver at that point would be obligated to answer every question, within some rules, but every question that the plaintiff's lawyer would ask him, including, isn't it true that you parked your truck too close to the roadway and that was an interference with the decedent's vehicle and contributed to the accident? The truck driver would be obligated to answer a question similar to that. That's a poorly worded question, but that would be obviously very incriminating towards the truck driver, and it could cause a jury to decide that they want to award the estate $10 million. Now, why that and not in the criminal context? Because in the criminal context, liberty is far more important than money. And the government, our founding fathers, understood this. And they understood that, in some contexts, somebody has to fess up to being guilty of something, but in other contexts, no. And now you understand why, in the criminal context, the government spends so much money in having a prosecutor's office with investigators, with training police officers on proper investigation techniques, with what you've heard of the phrase, the long arm of the law, and that's why it's long, because the government understands that it has to follow certain rules as it relates to prosecuting criminals. Okay, I've now exhausted everything I know about criminal law.
So then I have a question, a scenario.
Yes.
If someone were in a car accident, slick roads, wintertime, happened to have a wine or two before getting into the vehicle, is unconscious, is taken to the hospital, are they still allowed to do blood work without the consent while unconscious to charge?
Well, there's no question they can do blood work, all right, because if the person has been injured in the car accident, the blood work may be medically necessary.
Right.
And it may be that now we're starting to get into some limits of my knowledge, but there's probably nothing to keep the hospital from drawing the blood at the direction of the police officer or the county attorney.
Okay.
But there certainly would be a challenge to that in terms of whether it would be admissible. Okay. So again, go back to, you have the facts of an accident or the facts of a crime. A crime was committed. There's no question about it.
Yeah, because they were found over the legal limit. That's not the argument. The argument that that they're in the process of is, were they legally able to take that
Correct.
Take that reading without her awake and with that knowledge?
Right. Well, that's a search. That's actually what that is.
Oh,
It's a
okay.
search of their blood, okay, by doing that test. But there's a difference between getting the evidence and being able to use it in court. Those are two different things. So go back to my truck driver. Technically, when the police officer spoke to the truck driver over the telephone, he got evidence. Technically, he had evidence. And he technically had evidence that showed my driver had committed a crime. But he wasn't allowed to use that evidence because they hadn't followed some rules, and then we have the rule about self-incrimination. So in your context, your example, car accident, somebody had been drinking, found unconscious, goes to the hospital, the blood is drawn, they have a reading that shows that it's over 0.08, whatever. Well, the county attorney or the city attorney would have that evidence, but certainly I would expect that the driver's attorney would file a motion to suppress it's called suppression, motion to suppress the evidence, so that it would not be allowed because either there wasn't a warrant. Now remember, we went back to a warrant where a judge says you have the right to do this. There wasn't a warrant, or there wasn't sometimes things called exigent circumstances where the police can secure evidence in the absence of a warrant because the evidence may go away, and that may become a situation with the blood. I don't know. But yeah, it's tricky. And yesterday when we had our speaker here, who's unavailable today, he had a very favorite phrase, which was, "It all depends." You know, I mean, it's always dependent on a key fact or a couple of facts or a couple of things, the way things come into play. And that is, you know, that's the nature of trial work. That's, you know, in the medical field, I'm sure it all depends. It depends on what a reading is from a test or what a particular symptom is. You know, it's that way in the legal field as well. But because of this liberty thing in the criminal side, there are far more rules that apply to criminal cases. And let me just look at our outline here. And so one of those rules in the Constitution, again, and not in your written materials, but I will tell you because we can certainly get way into the weeds here, and we don't need to do that. But in the Constitution is this idea that you're presumed innocent until you're proven guilty. And that presumption of innocence applies in a couple of different ways. The very first way the presumption of innocence applies is that when someone is arrested, there is a requirement that within 36 hours, and that changes a little bit depending on weekends and holidays, but within 36 hours that somebody arrested has to be in front of a judge. And that at the time they're placed in front of the judge, they have the state has a requirement to tell the person who is charged with a crime exactly what the crime is, the nature of the crime, where the crime was committed, and essentially some more ideas so that the individual, the accused, has an idea of how to start to defend on that crime. Wonderful sound outside, thank you. And so at that point, at that 36-hour mark, doing construction. Oh, good. Okay. But when the accused appears for initial appearance, because of this liberty thing and this presumption of innocence, the court at that time makes a decision about whether the person should be released on their own recognizance or whether they should post some bond, or whether there should be no bond. I mean, no bond is that is an extremely rare circumstance. But a bond can be set so high, you know, $1 million for somebody who, you know, makes $20,000 a year. I mean, you know, at that point it is like an impossible bond. But a bond is nothing more than a promise that somebody will appear. And in our society, there is the philosophy that it makes no sense to hold people in jail unless they pose a risk of flight where they will not return to court, or they pose a risk of danger to the community. Yes?
For the amount of the bond, would that, if the higher it is, would that make what they would pay the bail bondsman more?
Yes.
And then if they can't pay that, could they land back in jail for not paying the bail bondsman what they owed them?
Well, the bail bondsman, well, let's talk how that works, okay? Released on your own recognizance, you don't pay any bail, all right? But they can also, the court can impose conditions on somebody's release. For example, you go get drug testing, or you get counseling for a drug or alcohol problem, something like that. Or that you report in every 24 hours with a phone call, or you have a monitor, right, that type of thing. But release on your own recognizance without having to pay any money. Bail, on the other hand, is a dollar amount that the defendant, the accused, needs to post with the court. Usually it is a percentage. So, you know, it's, you know, $25,000 bond or 10% cash, you know, something like that. So in that scenario, let's say it's $25,000 bond, 10% cash. All that they have to do with deposit is 10% with the court. So they only have to deposit $2,500. And the bail bondsman is not going to take that money over an installment. The bail bondsman is putting up the $2,500. So, but the bail bondsman, out of that $2,500 or $25,000, will take a percentage. And frankly, it's been a long time, so I don't know what kind of percentage they take. But let's just say it's 10%. So the bail bondsman wants $250 in order to put up $2,500 to secure a $25,000 bond. Please don't ask me to repeat that because I can't keep those numbers in my head. And so there is no bail bondsman that I know that's going to take that $250 in installments. So they'll get their money up front. They'll post the bond. The defendant gets out. And in theory, then, the defendant has a job and is able to work. And that's the whole idea. I mean, first of all, there aren't enough jail cells to hold everybody who gets arrested. But apart from that, you know, it doesn't help society to have people who are accused of crimes. Remember, presumption of innocence, to have them accused of crimes in jail while, you know, assume it's a man, to be stereotypical here, that it's a man with 3 children at home and a wife that works part-time. You put the man in jail and you don't let him out, the man loses his job, the family is at risk of losing their housing. So now you have, you know, people who are having to go to shelters and who may have to go on public assistance, you know, simply because somebody who was accused of a crime wasn't allowed out of jail. Now, remember, it all depends. There are exceptions for everything. And so people accused of murder, for the most part, stay in jail. People accused of violent crime like rape or robbery or something like that, or horrible assaults, they stay in jail, you know, with higher bonds.
And can't the judge decide if it's bail or bond?
Well, bail and bond are the same thing. They're both
But can't the judge put on that they can only bail and they have to pay it in full? And
Yes.
not bond out?
Well, pay it in full is still a bond, okay? A bond is just nothing more than the idea that it's a promise to appear, secured by something of value. And so the word bail, the word bond, they're really pretty much interchangeable. But yes, a judge can say, instead of allowing somebody to post $2,500 on a $25,000 bond, a judge could say it has to be $25,000. Absolutely. And so in that instance, we go back to the bail bondsman. The bail bondsman is then putting up $25,000, and the bail bondsman wants $2,500 up front from the defendant.
They can't pay for that, does that mean they just stay in jail?
Means they stay in jail. Yep. Until trial.
Okay.
So let's go back again now to the Constitution, that document that seems to drive everything here. And in the Constitution is a guarantee of speedy trial. The idea that defendants should not languish in jail forever. Who here read about the fellow who got arrested in Arizona and then sat in solitary confinement for 2 years without anybody knowing that he was there? Been arrested on a drunk driving charge.
Is that Arapahoe County?
Somewhere in Arizona.
Yeah,
We'll make no statements, but he had had some mental health issues. They placed him in solitary, and they forgot about him. Literally forgot about him. And you would see, and he had a lawyer pretty quickly when he got out of prison, and the lawyer did a really good job because he had a photograph of this fellow when he got out who looked like Rip Van Winkle, and photo of when he had gone in. He was clean shaven, and you know, and his teeth were bad, and it was, you know, well, $15 million later. Okay, that's why we know about that case, because a jury gave him $15 million as a result of being tucked away in a jail cell for 2 years. So the Constitution says you get arrested, you have the right to a speedy trial. In Minnesota, that means that you have a right to have a trial within X number of days. And I'm sorry, I don't know exactly what those days are, but it's within 2 months, approximately. And so to answer the question, you don't post the bond. What does that mean? Well, that means at least you have the right to appear in court, have some determination of whether you're guilty or not. I will also tell you this, and statistically, the vast majority of people who are arrested statistically are guilty of the crime that they're charged with. You know, and the statistics have been as high as 90%. I mean, I don't want to cite a specific statistic, but I'm going to tell you that the vast majority of people are. That does not mean, though, that the government isn't required to follow the rules as it relates to arresting somebody, how they're prosecuted, all of that thing. back to our truck driver. You know, the prosecution didn't do what they were supposed to do. Now, of course, this was only, you know, I mean, it was a small ticket. In the scheme, it had greater significance, but it was only a small ticket. But we want the prosecution to really follow the rules on very, very serious crimes. You know, crimes that capture the passion of the public. You know, think about, you know, for example, the Central Park jogger case in New York City. You know, where, I mean, there is now a documentary out by Ken Burns about the Central Park Five, about 5 African-American men who were right away charged with the crime and, you know, later exonerated from having done that. So the whole idea is that we want the prosecution, and that includes the police, to follow the rules. And because we all benefit from that in the end. All right, so right to a speedy trial in a criminal case. And then I want to get to this thing about presumption of innocence and what is the burden that the state's required to prove that somebody's guilty. Now remember, in our civil training, when we talked about civil cases, we talked about the idea that if there has been a controversy, the party that has been harmed or affected by that controversy who wants to have their rights vindicated. For example, Zoe Zalopa and Donatello Turtle, they had their car versus pedestrian accident. Donatello Fastani wanted to recover money as a result of being injured in the accident. And so Fastani filed a lawsuit, and Fastani then had an obligation to prove that Zoe Zalopa was negligent, that she had failed to exercise reasonable care in driving her car.
Filed a civil lawsuit.
Civil lawsuit, that's correct. Not a criminal one, a civil. And so, but it's no different. A civil lawsuit is a claim by one person against somebody else. A criminal charge is a claim by the state against someone else, and that charge being that you broke the law. With Fastani and Zoe, it was that you failed to act reasonably. You failed to act with reasonable safety, as you would with any person. So they're all both equivalent. But in the civil context, it is much easier to prove a case than what it is in a criminal context. In a civil context, the standard of proof is called preponderance of the evidence. All that simply means is that with all things together, all things even in the evidence of a case, all that the plaintiff needs to show is just that it is 1% more, if even that, more likely that the defendant was negligent, okay, than not. That's all that, you know, and so all a jury has to say is, you know what, it's a real close call, but I think it's probably more the fault of the defendant than it is of the plaintiff. And so, and even by just this little bit, and then the plaintiff is entitled to recover damages, money against a defendant. In a criminal case, the standard of proof is entirely different. That standard is called beyond a reasonable doubt. And so, in that context, what that means is that no reasonable person, considering the evidence, would have a reasonable doubt as to whether the defendant was guilty of the crime that was committed. So back here where it was, you know, 50%, but just a little bit more, the reasonable doubt standard is way up here. So there has to be really a standard of proof. And again, we get back to the state, the long arm of the government, their resources, and why do they go to such detail about the way they do their work? Because they have to be able to prove that it actually was the defendant that committed the crime and the kind of crime that that they're accused of. Now, it doesn't mean a juror can't walk away saying, you know what, I know that this person committed the crime, but I don't know if he did it with a hammer or with a baseball bat. I don't know what kind of weapon they used, but I do know that they committed the crime, because sometimes the weapon isn't recovered. And so that fact, if you don't, you know, you can have some doubt about what kind of weapon was used, but you can't have reasonable doubt about whether or not the defendant committed the crime. Again, way it works with our Constitution and why there are certain rules that the government has to follow versus on the civil side. Everybody with me so far? Okay, all right. How are we doing on time, Jay? Okay. All right. So, so then let's proceed forward with a criminal case. We've already talked about the crime, getting arrested, bail, and now let's talk about generally, and we'll get to Mary's scenario with the car driver and the car accident and the blood drawn, with what are called pretrial motions. And what happens many times in cases, and you have in your readings on page 3 a thing called a Rasmussen hearing, or a thing called an omnibus hearing. Rasmussen is just simply named after a court case where the defendant was named Rasmussen. What that essentially is holding the government to the rules that it's supposed to follow. So back to Mary's scenario with the blood being drawn, if the defendant's attorney says there wasn't a warrant and there wasn't probable cause to draw the blood and it was an illegal search, they would bring a motion before the judge, before the trial, and lay out essentially why the government violated the rules and why that evidence shouldn't be allowed. And the judge at that point will make a ruling as to whether that evidence is in or not. Now that's not a ruling as to whether or not the defendant should be not charged or should go free. It's really about whether or not the evidence is admissible. But many times what happens is that there's a piece of evidence that the police secured that shows that somebody's guilty, and if that evidence can't be admitted, then there's no case. The state can't prove its case beyond a reasonable doubt, and so then the state will dismiss, or the defendant's attorney will ask the court to order the state to dismiss the charges. So that's what happens. And an omnibus hearing is really not about evidence as much as whether it's about there was probable cause for somebody to be arrested. Probable cause is the idea that the police do not have the right to simply stop anyone on the street and say, hey, Kelly, give me who are you? And I want to see your driver's license. But you weren't doing anything wrong driving your car or walking down the street. Well, I don't care. I want to see, or I want you to empty out your pockets because I want to see if you got a crack pipe in there. Okay. All right. Just using it as an example. And so the idea is if the government didn't have probable cause, didn't have the right, because you weren't, as you're driving down the road, you weren't doing anything wrong. You just happened to be driving at 2 o'clock in the morning on a street where there weren't any other vehicles, and the police decide they want to pull you over. That's not probable cause. If, however, you changed lanes on that street without turning on your turn signal, so you went from the far left lane over to the right lane because a block up ahead you were going to make a turn, but you didn't turn on your turn signal to do that, that's probable cause because you have an obligation under traffic laws to use your turn signal. Now, of course, I know everybody here uses their turn signals, especially at 2 in the morning. But that is probable cause. And to use the example where the turn signal was used and the police still pulled somebody over, that it gets into a question of whether the police are trying to come up with some other kind of excuse. So the concept of probable cause, we hear about that quite a bit, and we hear about it many times when evidence is thrown out of a case or an arrest is thrown out of the case because the police didn't have the right to stop someone, and then everybody knows that the person is guilty, right? And so that's when it really comes into play. And I think that as I'm talking here to help highlight this difference between civil and criminal cases, some of you are too young to remember, but some of you do remember the O.J. Simpson case. Okay? And the O.J. Simpson case really is a clear example of the difference between criminal and civil. Because on the criminal side, O.J.'s defense lawyer, Johnny Cochran, was able to convince the jury that there was doubt, that there was more than reasonable doubt as to whether or not O.J. Simpson had committed the murders of the woman and the man that he was accused of having committed. You know, you may remember, if the glove don't fit, you can't convict, okay? So that was reasonable doubt that he instilled in the jury, and the jury came back and found him not guilty. Later, he was sued by the families of both victims for, I don't remember, it was millions, a lot of money. And in that case, he was found guilty. He was deemed, there was deemed to be, maybe there wasn't a criminal jury, didn't say that the evidence was like this, but certainly a civil jury said it was certainly this much that he had committed this crime. And, you know, and killing somebody, in addition to being a crime, is also a tort. You know, bodily injury, assaulting somebody, is in the civil side a tort. A tort is a civil infraction that one person commits against another. Yes?
How does that work with being brought to, and having a court case brought up on the same charge but differently? Is that different than double jeopardy?
You mean somebody facing multiple charges out of the same kind of crime? No, because let's assume somebody gets into a fight with somebody and hurts them very seriously. So they can then be charged with felonious assault, they can be charged with battery, they can be charged with attempted assault. The number of times you punch somebody or assault somebody. You know, you get into a fight and you start a fight and you have it, and then somebody tries to walk away, and then you get into a fight again. You know, each of those can be considered a separate crime. So that's not double jeopardy.
And if he were to, I'm sorry not to interrupt, if he were charged and found guilty and put in jail for that, and then say the person later died from his injuries, he can be brought back to trial under murder charges, because the person now, it has gone a step higher. So there's really, the double jeopardy thing is if they went to jail on a crime, and say
Charged
for
with the same
instance he
crime.
was found, you know, what would it be, like attempted murder, and then he got out and they found out that it was actually premeditated, there's really nothing they can do about it because he's already punished for it, right?
Right. Well, right. And likewise, if, for example, in that instance, the person is found not guilty by the jury, and the victim then dies, okay? So they're found not guilty of attempted murder, but then the victim dies, they cannot come back and be charged with murder because there's already been an adjudication about whether or not this person had committed a crime.
Yeah.
That would be double jeopardy.
Okay.
So, but you know, again, it goes back to that phrase, it depends on a lot of different facts, and you know, these are all very general examples that I'm giving you, you know, and so what we always, you know, this is also just general information, it's not to be conveyed, you know, as legal advice to any of your callers, but it does underscore the fact that in the criminal context, because liberty is at risk, it is really extremely important that somebody get a lawyer. And so on that context of getting a lawyer, let's talk about how lawyers are appointed for somebody who is arrested. At the time of that initial appearance, remember what, within 36 hours, generally somebody needs to be brought before a judge. In Minnesota, in at least most of the courthouses, there will be a public defender that would be assigned in the courtroom. Now, a public defender, you know, people commonly construe the phrase public defender to mean that it's somebody defending the public, you know, like a prosecutor, but that's not the case. Public defender relates to defending members of the public who are accused of crimes. Prosecution is the prosecution, or the city attorney is the city attorney or the county attorney. But in Ramsey and in Hennepin and in the metro area where we are concentrating our work and our referrals, there'll be a public defender in the courtroom for anybody brought in. And that public defender will stand with the accused when they have their initial appearance. So they bring them into the courtroom, sometimes in handcuffs, well, a lot of times in handcuffs, and when they appear in front of the judge, there will be a lawyer there from the public defender's office to advise this person to plead not guilty, or to say, I need more time before I can plead, and ask for another court date. And then that public defender will also argue about bail, whether or not a person should be released on their own recognizance, or whether there should be bail set. And the prosecution can either agree that maybe this person doesn't need to be on bail, or the prosecution can say there should be bail. But there's a public defender there. Now, the way the system works, because as your material reflects, there was a fellow named Gideon over 50 years ago. This is actually 2013 is the 50th anniversary of the Gideon v. Wainwright case. There was a fellow named Gideon who had been arrested for a relatively minor crime, but sentenced to jail in Florida, and who couldn't afford a lawyer. And so Gideon was somebody who ended up writing to the Supreme Court. He actually wrote a handwritten petition to the Supreme Court saying that he should be entitled to have a lawyer because his liberty was taken away from him. And ultimately, the Supreme Court ruled that everyone who's accused, who's at risk of losing their liberty, has the right to have an attorney. So now we're back into TV land with the Miranda Rights, where somebody is arrested and they're advised of their rights. And that comes from a whole other case involving a fellow named Miranda, which we don't need to get into. But one of those things that somebody's advised of is you have the right to an attorney. And if you can't afford an attorney will be appointed for you. That is the Gideon v. Wainwright case right there. Yes?
Have you seen a lot of cases where the minute that they say that they don't need an attorney? I've been in a situation where then the cops have gotten dirty. You've already given up that right, and then it's like they have free reign almost to just, I don't know, that's been my experience.
Well, the fact is you never give up the right, okay? You always have the right to stop talking to the police. Mm-hmm. So you have the right to start, you can start talking to them, and then if they ask you one too many questions, you say, you know what, I'm done speaking. Now, most people don't know that. And the majority of people do waive their Miranda rights. Okay, so I just used the word waive, and by that I mean they agree to talk to the police, okay? That's what the waiver is, but it is not a permanent waiver. You can say, the police can say, what's your name? You can say, my name is, Joe Schmo, and then you can say, you know what, I'm done talking to you. And the police can't say you have to keep talking to us because you waived your rights, all right? But people don't know that. And the vast majority of people do waive their Miranda rights because the vast majority of people think that if they just explain it, okay, the police officer will get it and they'll leave them alone. And that is not how it works. So, and police officers they're trained interrogators, and they're trained, and again, this is the government, the long arm of the government, doing its job as general citizenry wants it to do its job. But one of the rights being you have the right to an attorney. So what a judge will do at that initial arraignment, initial appearance, is the judge will question, and this varies from courthouse to courthouse. So what is your response on the telephone? Your response is, let's assume it's a wife calling, my husband is in jail, he was arrested 6 hours ago, I don't know what to do. Your response will be, ma'am, he's going to see a judge at some point fairly soon. And there will be somebody there, there will be an attorney there that he'll be able to talk to in the courtroom, right? That's, apart from that, we don't give advice, but I mean, what you're doing essentially is stating a fact. And the judge will then make a decision when the person appears. The judge will ask, sometimes it's a written inquiry, Sometimes it's verbal inquiry, sometimes it's detailed, sometimes it's not. It all depends. But the judge will ask, or somebody will ask, do you have a job? Do you have a place to live? Who do you live with? Because that can be crucial, because if they're accused of domestic abuse, they no longer have a place to live. And then a quick determination will be made whether you can afford a lawyer or not. Now, sometimes those determinations are wrong. And if the determination is wrong and somebody goes out and searches for a lawyer, because let's assume they're released on their own recognizance, judge says, we're not going to, you don't have to post bond, but you have to come back to court. Everybody who gets arrested, for the most part, has to come back to court. And they get a promise to appear. They get a document that says, here's your next court date, you better show up, which is pretty darn important. Because if they don't show up, then they're subject to being arrested for failing to show up. But if somebody goes away, the judge says, no, you're not going to be appointed a lawyer, you're not going to be appointed a public defender, and they go away, they can't find a public defender because they can't afford one. They can't work out a deal with a criminal lawyer. And they come back to court and say, Your Honor, I can't find a lawyer to represent me. Then there'll be another inquiry about finances. The point here is, no one will ever be required to stand in front of a judge or a jury trying their case on their own. Everyone will get a lawyer. Now, the quality of lawyers differs, just like the quality of auto mechanics differs, the quality of chefs differs, and someone who's appointed a public defender doesn't have the right to say, I don't like this one, I want that one. Unless there are, fundamental issues with that public defender. But that also reinforces a point that on the telephone, you do have the ability to say, if somebody says, I don't like this public defender that I have, I want you to help me find another lawyer. I mean, it is not advice, it's not legal advice, it's just human condition statement. You always have the right to ask your public defender why they're not doing what they're supposed to do, you think they're supposed to do, and you always have the right to talk to their supervisor. How many of us, when we get something in the restaurant that we're not happy with, the food's cold or this isn't what I ordered, we tell the server, this is not what I wanted. And if the server is rude, sometimes we go to the supervisor and say, you know what, I'm not getting the service I'm supposed to get. And that's really what it's no different in the legal field. So people have to be their own advocates as it relates to legal services, generally. And you can point that out to your callers. I'm sure that's not going to be a very, very detailed telephone call, but people can be reminded about the right. They have the right to speak up. Okay, so for the most part, well, not for the most part, no one will be required to try a case without a lawyer. Yes.
I was on a phone call just a couple weeks ago where the police officer had entered the home of someone that obviously had mental health issues. I mean, they were seriously just going off on these cops, saying like every swear word in the book, just like, you don't have the right to be in my home, and they probably didn't. He was telling me they had no warrant, but yet they were there searching his home. And then in the midst of that, the guy that was screaming, he was just totally off the chain, and he said, I guess they took him down because he threw like a piece of paper or something at the cops, but they took him down, and the phone fell out of his hand, and he was sitting, and he was a disabled person, so he was sitting there like just screaming and like begging for his life, and it sounded absolutely crucial. But I was like, who would you, I mean, of course there's the Civilian Review Police Authority, but I don't know, it didn't seem like those cops really actually had a right to be in there, and although he was acting very inappropriate, I think that was his level of capacity, and it concerned me when they had him down on the floor and he was like begging for his life, saying that I'm disabled in this certain way where you're cutting off my, oxygen, something to that effect. So who would you report that to? Other than being the obvious, I guess, calling the police department and speaking to their, it was just one of those moments where it kind of, reminds me of a lot of the things you're talking about. So.
Well, and that call, I mean, I'm sure we don't get very many of those kinds of calls where, you know, in that instance, you know, I think that it would be a really difficult call about what do you do about it. I mean, obviously, you've got the police there already.
Yeah.
If you really do believe that something is happening that is reflective of something improper, I think that your only response is to call the police department again and say, you know, this is happening at this house. Somebody should be paying attention to this.
Yeah, I mean, because if this guy ever had called us and wanted the tape, you know, for his own purposes, as far as like to actually get a lawyer, I really think that the police department would have been in huge trouble. You know, they didn't have a warrant. They were in there. They were looking around. He did, I don't know if you want to say assault so much, because I think he threw something at them.
Yeah, that would be, no, that would be assault.
Well, yeah, but I'm just saying that it was already, the fact that they had already crossed the line.
Right.
So you're almost he could have said something like self-defense.
Well, you know, these are all very tricky facts, and it goes back to that phrase, it all depends. But what I would tell you is, you know, in that kind of instance, if you know, consistent with whatever Ceridian 211's audio tape preservation policies are, is, you know, that be done. That be preserved, or that you speak with your supervisor about it as to whether or not it should be preserved for a longer period of time.
Well, it can be preserved, but in the same aspect that you were talking about, his lawyer could subpoena the tapes.
That's correct. His lawyer may not also know that there are tapes.
Right.
So that would be probably more common that the lawyer would not know that there are tapes of the calls. And am I assuming that every call is taped?
Mm-hmm.
Unless they ask not to be.
Yeah.
Unless they ask. Okay. All right. And they get that. They do get that as they're on the queue.
Yeah.
All right. Okay. Well, I guess all I would say is stay tuned, and maybe that person will call back. But I think that your only response to that situation would have been to call the police officer and say, you know, somebody, a supervisor needs to be aware of what's going on.
Just call 911. No, but, I mean, yeah, but at the same time, okay, where's he at?
He was in his
Other
own
than you got
apartment.
it, I know, but do you have the address?
He has a phone number. And I'm
Is he
guessing
calling from a
didn't
cell
have
phone? You know, it's kind of hard, because if he does have mental disabilities, was he threatening people outside the apartment? Was he, I don't, you know, there could be other reasons as to why they were in there. So that one's hard, but on the lighter note, I got arrested 3 years after a speeding ticket for not paying the ticket. And they were like, well, you know, you could pay us $130 now and just go home. No, I paid that ticket, so, you can go ahead and take me downtown, I don't care. I'll go to court in the morning, because I knew I had to go to court in the morning. Now, the next morning, when I went there, so they had to take me out to Southdale. I said, okay, let me talk to the public defender, because my husband will be coming down with my check receipts, because, you know, luckily we had some other things going on, so we had those for a while. And they're like, okay. So he comes in and we're talking, and he's like, oh, don't even worry about it. We'll get this taken care of. You don't have to pay anything. Maybe $50 in court costs. Well, I don't want to pay that either, because the receipt's on its plate. Okay, he said. So when they called my name, their judge is stating what he's got to state, and the person who reads the case off is reading it off, and the public defender introduces himself, and they ask me if I'm who I am, you know, well, yeah. And a gentleman stands up in the audience. Well, no, I'm Mrs. So-and-so's attorney on another matter. What? No, that's not me. No, Now, mind you, I have the same name as another relative in my family, who sometimes isn't the nicest person in the world. I was like, no, Judge, that is not me at all. And he said, okay, why don't you guys step out, figure out what's going on, and come back in. Well, that guy then dismissed my public attorney and came back out and said, I am so apologetic. I heard the name, I didn't pay any attention. This is not my client, that's a whole nother person and a whole nother matter. But I'll represent her for free because, you know, this is my fault now. You know, I was like, oh my goodness, no, that's not me. Because he's like, on
well,
an assault charge. And he's like, oh, no.
Well, that shows you, I mean, you know, the system obviously is not infallible, and, you know, there are always, you know, always wrinkles with everything.
And that could be as simple as they came because his name could have been somebody else's name. And because he didn't have the mental capacity to either articulate it correctly or stop them correctly, and they came.
Right.
It's,
I probably would just call the police department and be like, so I don't know if you know that this is going on, but I thought you should at least know that this is.
and you can conference it, yeah.
Yeah, and worst case scenario, you call them when they didn't need to be called. It's better to call them when they don't need to be called than to not call them.
Right, and
I'm one of those people that doesn't trust the police. They're not, I really don't trust them. I mean, it really, they're just there to do their job, and I've dealt with great ones, but I've also dealt with those that don't really have any concern for your own, you know, so I wouldn't really, that's not something that I would do, because I think that they so much think that they're always in the right, that I don't really think that would go anywhere. If I was to call them, I would talk to like their supervisor.
right.
I wouldn't just talk to the first person that answers, you know, the phone at the police department.
Well, you know, I mean, every situation is different. We get into these gray areas, but as we've talked before about scenarios, which is err on the side of caution, you know, always err on to the extent that you need to protect whoever the caller is, and talk to your supervisor. You know, help whoever, you know, is your supervisor, talk with them and get their input on what might be the right thing to do. You know, remember, you know, some scenarios where it's if somebody's at risk of personal injury, in some other context, you know, make sure that you dial 911 to help them. All right, we've got about 15 minutes, and let me just cover some other things before we're done, okay? Criminal expungements. Your training materials have about a page and a half about criminal expungements. We hear about this, you know, we've talked about expungements generally before. Remember when Larry McDonough came in, we talked about expungements as it related to the landlord-tenant area. And with criminal expungements, it is a very tricky area. You know, for people who are accused of crimes, but the crimes are never prosecuted or the charge is dismissed, there is a much easier process for that person to go through and obtain a criminal expungement. But for people who are convicted of crimes, to essentially what expunging a record is essentially someone asking society to say that this crime did not happen, you know, or that the crime was not significant enough that society should keep a record of it. That is a policy decision, essentially affected by the judge in conjunction with the county attorney or the city attorney's prosecuting office. Because for everyone who's filed an application about a criminal expungement, they have to give notice to the county or city prosecutor, and the county or city prosecutor has the ability to come in and weigh in and say whether or not they should allow the expungement, whether the expungement should be granted. Now, they could object, and the court can still grant an expungement. The odds are that if you have somebody who has multiple criminal convictions or guilty pleas, you know, 5 or 6 or 7, the odds of getting all of those expunged are probably pretty remote. Now, it's possible that if those 5 or 6 took place when somebody was 21 years old and now they're 50 years old and they're coming in and they need to have this for public housing or for some reason, you know, then maybe all of that will take place, that they'll be able to be granted the expungement because the charges are 30 years old. However, if you have someone who has one charge, only ever, one conviction ever, and it happened 10 or 15, 20 years ago, then the odds of getting that expunged probably are pretty good, because Maybe somebody made a mistake, they've paid their debt to society, now they've moved on, and now they're a different person in what they are. We all know that at 50 we're not the same person we were at 20, thank God. And so, so that, generally that's how expungements work. There are, when VLN came in, and Martha Delaney was here last month, she talked about them running some criminal expungement clinics. My advice would be, no one should try and do expungements without talking to a lawyer, getting at least some advice or run by with an attorney. My recommendation is for our expungements, send everybody to the court self-help centers where they can at least get started with the process, get the paperwork. For example, in Hennepin, they will explain to the applicant for the expungement how the process works, what they need to go through. Certainly we can refer them to VLN. Lawhelpmn.org also has resources about criminal expungement. Again, it's a lengthy process. It takes time. It takes applying for it. It takes paperwork assembly. And it is the type of thing that someone should not do without an attorney. So, does everybody here, do we get a fair number of calls about criminal expungements?
Yep.
Okay. All right.
Those lawyers are employed, right? They're not volunteers.
What lawyers?
Volunteer Lawyers Network.
No, well, the Volunteer Lawyers Network are lawyers that act on a pro bono basis, so they all have day jobs, like they work at law firms, or some of them work for private employers like Target.
The reason why I'm saying that is just someone on the phone this week wanted to argue with me that they were retired lawyers that couldn't get any other cases, so that's why they were there. And I was trying to say, no, that's not the case. You got a misunderstanding.
That's correct.
And they're not volunteers. I think that's a little bit misleading, but
Well, they're volunteering their time.
I suppose pro
Okay,
bono.
pro
Sure.
bono.
Okay.
There you go. See, you got your training. You got it down. You understand. But of course, that is, we know this. We've heard this before from some of our speakers. People who provide nonprofit legal services, people from legal aid, pro bono lawyers through VLN, some of our other nonprofit legal providers. You know that there is a public perception that if there's not a charge for the legal service, that somehow the lawyer's not as good as a lawyer who charges, which is an absolute, total misconception. I mean, lawyers from legal aid are darn good lawyers, and they really know their stuff, and and in the area in which they practice, they know far more than lawyers who work with law firms. And so, of course, we want, on the phones, we want to be, disinstilling. Is that a word, Jillian? We want to, be telling folks, no, you have a misperception. And it sounds like you did a really good job about that, so thanks. Okay, so let's talk about what our resources are and what our referrals should be. We have here a number of referrals, and if we go to pages, let's see, pages 8 and 9 of the training materials, you see that we have everything broken down according to county. So in Hennepin, now remember, we're doing primary and then fallback referrals. So you get a call about, I'm going to get charged, or I've gotten charged, but I don't have a lawyer yet. So remember, it could be somebody who the judge believes, no, you make enough money to find a lawyer, to hire a lawyer, and now you're getting the caller saying, I've looked for 2 weeks and I can't find an attorney that's willing to work with me on a fee. So then your primary referral in Hennepin would be to the Hennepin County Public Defender, and then the Legal Rights Center. And the Legal Rights Center is a resource that is a public defender entity. And remember, in Minnesota, there is the State Public Defender's Office. They oversee all the public defenders in each of the judicial districts. And then in addition to the public defender in each county or in each judicial district, then they've set up 4 separate specialized public defender organizations. And so the Legal Rights Center in Hennepin is a center that is oriented and focused on representing people of color and other underrepresented groups. Now here's the thing to write down about the Legal Rights Center. If somebody goes to their website is going to tell them that their intake, the only time they're going to be accepting potential clients are Tuesdays from 10 to noon. That is what the website says. If they call, though, they get a different message. And if they call, they get a menu that goes on for about a message that goes on for about a minute and a half, and then talks about these other intakes that are down here. So you don't see on the website that they have a Somali-speaking only intake at the Bryant Coyle Center. You don't see on the website that every Wednesday from 10 to 11 and 4 to 5 there are other intakes for English only, or that there's Spanish intake on Thursday at Clues. So yes.
So for those, do they have to walk in for intake, or do they call those agencies?
They can call, but I think that, the reason I have here is that they can walk in.
Okay.
Yep, those are walk-ins. That's correct. Federal public defender. We haven't even talked, now remember, we've spent all of our time talking about the city and the county prosecuting somebody, but the federal government also prosecutes people for crimes. Usually those crimes are way bigger crimes. The federal government does not prosecute for simple assault. Now, you commit assault that is, because it's a hate crime, you have a person of one color assaulting a person of another color, and the reason is because of that other person's color. Oh yeah, then the federal government will get involved. But regardless of that general statement, for federal crimes, people are also entitled to lawyers, and there's a federal public defender. I'm going to assume you don't get many people calling about federal public defenders. Okay, but they exist, just so you know. Misdemeanor Defense Project in Hennepin County. The Hennepin County Bar Association arranges for a lawyer to be at every courthouse on misdemeanor day. And that lawyer will make an announcement. If you don't have a lawyer here, and you want to talk to an attorney, the lawyer will say, "Come and speak with me." And that lawyer will not provide representation, but will provide education. So here's what you can expect, person charged with a misdemeanor. You have the right to ask the county attorney to show you what the police report says. You have the right to, if the county attorney or city attorney may want to talk with you about a plea deal. So instead of being speeding 25 over, they may say you can speed at, we'll knock it down to speeding 10 over so that you don't automatically lose your license, you just lose points or gain points or whatever, however it works. I want to know how it works. Okay, and so anyone calls, in Hennepin County, they go to misdemeanor court, there'll be a lawyer there for them to talk to. And they can later on work out if they want that lawyer to represent them. Finally, remember we've got the Hennepin County Lawyer Referral Information Service. All of our training now for over a year has been on the civil side, and we've been referring to the Hennepin County Bar Association Lawyer Referral and Information Service, LRIS, on the civil side, but they also do criminal referrals. So that would be for people who have resources. Yep.
I've heard that the American Civil Liberties, that they deal with complaints of misconduct in prisons, kind of like an ombudsman types. And I'm just wondering if you're familiar with any services that they have available to the public, because it seems like they do, but we don't have them registered for that. So I'm just wondering if you're familiar with their, involvement.
The ACLU will not do just general criminal defense work. The ACLU gets involved when there are cases representing serious policy issues. Mm-hmm. So, for example, if there's a pattern of police harassment or abuse in a particular community, the ACLU will get involved then because they want to highlight or deal with whatever that harassment is. And I don't want to keep picking on the police, but the ACLU will get involved with, they may get involved with hate crimes. Actually, the ACLU may get involved with crimes where a defendant is charged of something heinous, and there's an issue, for example, a speech crime, a crime relating to speech, but everybody, for example, somebody who wants to conduct a march gets arrested because they don't have a permit for that march. But it's the Ku Klux Klan that wants to march. Right? So most people would say, you know, we don't really want them marching down the middle of Edina. And the ACLU will become involved with that. And they'll represent the Ku Klux Klan because they'll say that that's an impingement on everybody's speech, free speech for the principal.
I'm assuming it's lawyers that contact them and mostly get their involvement going on.
They do, and the ACLU...
Sometimes maybe personal calls. But
The ACLU does not, I mean, they have some staff lawyers, but mainly what happens with the ACLU is that they recruit lawyers to represent people with ACLU cases. So they're like the VLN, but only on the civil rights side or the policy rights side. Okay. Also, in Ramsey County, you've got the Ramsey County Public Defender's Office, and then you have the Neighborhood Justice Center, which is essentially the equivalent of what's going on over on the Legal Rights Center in Hennepin. Criminal Defense Services, I understand from speaking with Vicki, that's not in your database. It is, remember we've talked about low bono on the civil side, both in Hennepin and Ramsey, the family law referral over in Hennepin and the Ramsey low fee service in Ramsey County. The Criminal Defense Services in Ramsey is the criminal equivalent of low bono. So what they do is they have lesser fees for people based on income, and the Criminal Defense Services gets part of the fee, and then the defense lawyer who's doing the work gets the rest of the fee. The Criminal Defense Services has the very same address as the Ramsey County Public Defender's Office. And that's because I think that it's an arm of the Public Defender's Office trying to deal with that people caught in the gap who make too much for a public defender, but who can't afford the $350 an hour criminal defense lawyer.
Have they been doing that a while?
You know, they have, and this is why we train on it. So they've been in existence.
So they've been around for a while?
They have.
Okay.
So, and Vicki is working on getting them into your database. You've got the Ramsey County Courthouse Law Library where they're doing expungement work. And I have that in there. And again, we all know the county law libraries, here in the metro area, many of them have law librarians, and our law librarians are fantastic resources. They can't provide legal advice, but boy, do they want to help people. So, make sure you refer your callers to law libraries and make sure that the callers speak up and they actually talk to law librarians. Ramsey County Bar Association, that referral service is there as well. Okay, we have 5 minutes, and so shall we talk about Zoe?
Yes.
Okay.
Zoe's going to jail. I don't know how she thought to go to the.
I heard the title, Zoe Goes Crazy. I'm like, oh, and she just.
Right.
Who died?
All right. So to recap, Zoe's going on with her life a little bit, and she had done her taxes, and she was ready to get a tax refund, believing that it would be $58.01 from the state of Minnesota. Came home from work one day, opened an envelope from the Department of Revenue, and inside she found a check for $580,001. Not knowing what to do, Zoe decided that she would go to the bank and deposit the check into her checking account. She did that, and then that night, still not knowing what to do, she got online and went to Amazon, Nordstrom, Zappos, Victoria's Secret, Crate & Barrel, 50 other vendors, and before she knew it, she'd ordered $15,000 worth of clothing, shoes, kitchen appliances, and the cutest little salt and pepper shakers shaped like his and her dachshunds. 3 days later, the goods start to arrive at the apartment, and Zoe finds that there's a message on her phone machine from Herb Tightnickel of the Minnesota Department of Revenue, who said, "Mrs. Lopa, there's been a mistake. Please call us." Zoe didn't know what to do. She did what anybody normally would do, had a glass of wine and went to bed. The next day, she went to work. When she got home, she found 25 packages stacked in front of the apartment door, started opening them, and eventually saw another flashing red light on the telephone answering machine service on the machine, and it was Mr. Tightnickel again, telling Zoe that the bank records show that the check had been cashed, and now she probably should get a lawyer because she'll be hearing from the State Attorney General's office. Zoe poured herself another glass of wine, of course, and then she called you. So what kind of referrals would we make, bearing in mind that Zoe is in Hennepin County? And poor Zoe, she does get herself into trouble, doesn't she? So what kind of referrals would we make for Zoe?
Take all the money and skip the groceries.
Shoppers Anonymous.
I don't think that, yeah, I don't think those would be the referrals. Shoppers Anonymous, maybe. Maybe the referral would be, why did you only spend $15,000? Well, of course, in Hennepin, we would refer to the Hennepin County Public Defender, because the public defender not only will represent once you've been charged, but they do make clear that they will consult with somebody who is subject of a police investigation. So, and remember, you know, it's not legal advice. If somebody calls and says, the police want to talk to me or the county attorney's asked me to talk to me, it's not legal advice to say, you know, you should consult a lawyer, okay? You know, don't say, don't talk to the county attorney. You don't say, you know, go there and you've got these Miranda rights. What you say is, you know, you should consult a lawyer. That's where you should leave it, okay? But the
A criminal lawyer.
criminal lawyer, that's correct.
In this instance.
That's correct.
I'd actually usually send them to the Legal Rights Center first, because don't they
Good.
give advice no matter what your income is? At least like, well, we
At
can't
least
help you, but
steer you.
right.
Yeah.
Whereas
Yeah.
the public defender's just like, no, unless you're appointed by the court.
No, you know what, and that very well may be a good primary referral to the Legal Rights Center, or,
Wouldn't the
That's, like,
volunteer lawyers
seriously not
network
true,
do the
though.
same thing though?
hold on a second. Yeah, the VLN, you know, I don't, you know, I'm not, you know, the VLN may steer, but I'm not recommending that we do that, because VLN is really set up for civil.
Okay.
Okay, what,
I have had a public defender, never court appointed. I had to advocate for myself. I went to them. You don't have to be court appointed. And I just get so annoyed when I hear that, because it's just a misconception. It's not true.
well, did they take your income into account?
Of course.
Okay.
I mean, yeah, they'll ask you questions on paper, yes.
Right,
And
and
it's
so.
not like an automatic, but it's not like the court said that, here, you're gonna have a lawyer. No, I had to go about that myself.
No, there's no question, but in your instance, if you had gone back to the court and said, you know, I've tried everything I can to find a lawyer, Your Honor, and I can't find one that will represent me, the court is not going to make you go try your case by yourself. That is against your constitutional rights.
Oh, for sure, yeah.
So eventually you would get a lawyer one way or another.
Yeah.
But I think what you say, though, again, is a really important point, which is about advocating for yourself. And it's not improper for us to say, you know what, you know, as you go through this system, and if you need to, send them to our website, because our website, we have the top 10 things that you need to know about navigating the court system. And one of those is that you do have to be your own advocate. You know, you have to.
It's kind of like healthcare.
Kind of like it. No, it's exactly like healthcare. So Zoe, you know, stay tuned. We'll see what kind of trouble Zoe gets into next month. We are at the end of the training. Does anybody have any questions about anything?
I have a question. In the section where it talks about expungement, it mentions getting your records. And I know that the BCA is one place that you can get those records, but can you still get them? At one point you could at the police station, because I have callers that ask and want to know about getting the records from the police station.
I don't know. I can't tell you.
Well, a lot of our police stations have records.
Because that's where
Yeah.
I've gotten mine in the past, but it was years ago. So I just
So I mean, in RIDA, under some of the police stations, it will say records.
Yeah,
Yeah,
I mean, they
special
can also go to the courthouse. They could go and ask the clerk of court.
And what about internal affairs? With the sheriff's office and police stations, if there's not internal affairs, then you just have them speak to supervisors?
That would be my, yeah.
Okay.
Yep, and then if they don't get any recourse there, send them to the Attorney General's office. Because ultimately, the Attorney General's office is what oversees all of the different county attorneys' offices. I mean, when there's a dispute or there's a problem, that office gets involved to try and deal with ethical issues as it relates to county attorneys.
What about the lawyer responsibility board? Is that the other?
Well, that would be through the Supreme Court.
Okay.
That's if there's an issue or a complaint about a lawyer.
Okay.
about a lawyer's ethics or how they're dealing with somebody. And everybody using a lawyer, criminal or civil in the state, has the ability to file a complaint or to go online and find out if the lawyer has been the subject of complaints. Next month, we are going to have, speaking of the Attorney General, we're going to have somebody from the Attorney General's office to talk about identity theft and also about how the Attorney General's office works. So, I mean, we do make a number of referrals to the AG. Yep. So I think that would be helpful for have them come and talk, okay? You guys have done great again. Wonderful questions, great dialogue. Did it look like I don't know anything about criminal law?
You would have never known.
Okay. Well, thank you very much, and that concludes our training for today. Thank you.
Thank you.